Imagine running your business, you've got contracts in place, everything seems solid, and then one of your key partners seems to just change their identity overnight.
Yeah, like poof, a new name. But is it just a name? Or is it a whole new company?
Exactly. How do you navigate that? Especially
Yeah.
when they claim it's just a simple name change, but it might actually be a maneuver to, create a totally new entity, maybe leaving you exposed.
It's a tricky situation, and it's precisely what happened in a really fascinating Philippine Supreme Court case we're diving into today. It touches on corporate identity, keeping contracts sacred, and crucially, the personal liability of the people behind these moves.
We're going deep into a case that really highlights the complexities you find in corporate dealings and the principle of good faith or the lack of it sometimes.
We'll trace how this whole dispute played out, from the initial agreement right through the lower courts and up to the Supreme Court's final word.
So for everyone following along, the case is Total Petroleum Philippines Corporation petitioner visas Edgardo Lim and Tyreplus Industrial Sales in trouble or respondents.
And the citation, that's GR No 23566, and it was promulgated on June 23, 2020.
Okay, let's set the stage. Who are the main players here?
Right. On one side, you have Total Petroleum Philippines Corporation, we'll call them Total. They're in the business of making, importing, selling automotive products, industrial lubricants, that sort of thing.
And on the other side?
We have Tyreplus Industrial Sales, Inc., or Tyreplus. They market automotive parts, oil, lubricants, and importantly, Edgardo Lim is their president.
Got it. So how did this relationship start?
It began with a contract. On December 1st, 1999, Tyreplus, with Lim signing for them, and Total entered into a commercial distributorship agreement.
What were the key terms?
Well, it was set for 12 months. It gave Tyreplus the authority to distribute Total's products in a specific territory. Importantly, it was non-exclusive, and maybe even more importantly, it was explicitly non-transferable.
Not transferable. That sounds like foreshadowing.
Definitely. Article 2 laid out that non-exclusive, non-transferable authority, and even had a non-compete clause for Tyreplus. Article 4 detailed their duties. Efficient marketing, keeping up quality, not selling outside their area, providing forecasts, allowing inspections, the usual stuff.
Seems standard enough. Lim even bought, 6 vehicles for distribution?
He did, although apparently some weren't used exclusively for Total products, which might be a minor point, but, it's there.
Okay, so far so normal. When did things start to shift?
Things got interesting right at the end of 1999. Tyreplus' general manager resigned, and Lim took over the day-to-day operations himself.
And this is where the name change idea comes in.
Exactly. Lim started saying Tyreplus needed to change its name to Superpro Industrial Sales Corporation, the reason he gave, to shake off a supposed bad image left by the previous GM.
Okay. A name change to fix an image problem. How did he communicate this to Total?
Formally. On January 31st, 2000, Lim sent a letter to Total. But crucially, it was on Superpro in Sales Corp letterhead. And in that letter, he stated that Superpro Industrial Sales Corporation would be the new trade name of Tyreplus Sales Corporation.
Using the new letterhead already. Did he follow up?
Oh, yes. He met with Total executives just days later, February 4th, and repeated the same thing. It's just a name change.
So he's consistently pushing this narrative. What happened next?
A really key meeting on February 10th, 2000. Lim met with Total executives again, reiterated the name change story, and then handed them Superpro's articles of incorporation and its certificate of incorporation.
Ah, the actual incorporation documents for Superpro. What do they show?
This is critical. Superpro's official documents, dated just 2 days earlier, February 8th, made absolutely no mention of Tyreplus being a predecessor or having any connection. It looked like a completely separate, brand new company on paper.
Oh. So one story verbally, another story in the official documents he just handed over. How did Total react that day?
Well, this is where it gets really tangled. On that same day, February 10th, Total signed a new commercial distributorship agreement, this time with Superpro. The terms were very similar to the Tyreplus agreement, identical clauses in Articles 2 and 4. And Lim signed this one too, but as president of Superpro.
So despite getting documents for a seemingly new company, Total signed a new agreement, possibly still believing it was just Tyreplus rebranded.
It certainly seems that way initially. And after this new agreement was signed, Total products that were meant for Tyreplus started being stored and distributed by Superpro.
The lines are definitely blurring. Did anything else happen around this time to maybe reinforce the idea that Superpro was taking over for Tyreplus?
Yes. The very next day, February 11th, PS Bank sent Total a letter of undertaking. It confirmed Lim had assigned a P500,000 bank guarantee specifically to answer for the obligations of Superpro and its predecessor, TyrePlus.
And its predecessor, TyrePlus. That wording seems designed to link the two, doesn't it?
It really does, and Lim kept reinforcing it. On February 26th, again using Superpro letterhead, he wrote to Total assuring them that all billings to TyrePlus will be guaranteed payment by Superpro.
Okay, guaranteeing TyrePlus's debts.
Yeah.
But did he say anything else in that letter?
He did, and it's quite something. On that same date, he explicitly described Superpro as being fresh from its creation after dissolving TyrePlus. And he enclosed 5 post-dated checks from Superpro's bank account payable to Total for TyrePlus's outstanding balance, about P447,000.
Wait, so now he's saying TyrePlus was dissolved. That contradicts the name change story and contradicts the fact TyrePlus apparently still existed legally.
Precisely. The narrative kept shifting. It seems like he was trying to have it both ways, assuring Total that Superpro would cover TyrePlus's debts while also setting up Superpro as this new entity.
How long did this balancing act last? When did Total start pushing back?
Not long after those checks were sent. On March 9, 2000, Total served TyrePlus with a notice of pre-termination of their original agreement. They also demanded payment for unpaid deliveries, around P473,000. And shortly after, they terminated the Superpro agreement too.
So Total decided to cut ties with both. How did Lim respond to the termination?
On March 17th, Lim wrote back, basically reminding Total that they were informed about the name change and Superpro taking over TyrePlus's debts. He even emphasized that TyrePlus's dissolution was purely on my own prerogative. Again, sticking to that dissolution idea.
But the real bomb dropped shortly after, right, with the checks?
Exactly. On April 10th, 2000, Lim ordered a stop payment on those 5 PS Bank checks he had issued from Superpro's account.
Wow. After assuring payment, he stops the checks.
Yeah.
What was Total's realization by this point?
By late March, Total seemed to have figured it out. They sent a letter on March 30th explicitly stating they found out that Superpro is an entirely new organization. They cited their policy of only wanting one distributor in a given marketing territory.
And did they connect this back to the original TyrePlus contract?
Yes. They pointed to TyrePlus's breach of Article 9, the non-assignment clause, as the justification for pre-terminating that agreement. They argued TyrePlus had effectively assigned its role to this new entity, Superpro, without consent.
What about that bank guarantee? Could Total access that?
No. PS Bank told Total they couldn't release the funds because Lim, in his capacity as TyrePlus president, hadn't formally agreed to pay Total's claim from that guarantee. Another layer of complexity.
Unbelievable. So Lim stops the checks, blocks the guarantee access. What was the next step?
Litigation. TyrePlus, incredibly, sued Total first, claiming damages, moral, exemplary, actual damages for expenses like those vehicles, plus attorney's fees.
TyrePlus sued Total after all this.
Yep. And Total naturally counterclaimed. They sought payment for TyrePlus's unpaid obligation, liquidated damages, actual damages, exemplary damages, and attorney's fees. Their core argument was that Lim had transacted in bad faith.
What a mess. So this complex situation, with accusations of bad faith flying around, lands in the courts. How did the regional trial court see it?
The RTC, that was Branch 10 in Davao City, they issued their decision on November 15th, 2005, and they ruled squarely in favor of Total.
What was their reasoning?
They found that Total was completely justified in pre-terminating the agreement. The judge believed Lim had actively misled Total, making them think TyrePlus had just changed its name to Superpro when, in fact, he was setting up a new, separate company.
So the RTC saw through the deception. What did they award Total?
They ordered TyrePlus to pay Total the P472,926.30 Benny for the unpaid products, plus P25,000 in liquidated damages, P60,000 in actual damages initially, and attorney's fees.
And I think there was a modification later.
In May 2006, the RTC increased the actual damages award to P401,308. That was specifically for advertising and promotional materials Total had delivered to TyrePlus. So a pretty comprehensive win for Total at the trial court level.
Okay, so Total wins round 1, but TyrePlus and Lim appealed, presumably.
They did. It went up to the Court of Appeals, or CA, and the CA's decision, which came out on February 29, 2012, completely flipped the script.
Completely reversed the RTC. How?
The CA saw the facts very differently. They concluded that, actually, TyrePlus had not ceased to exist. There was no formal dissolution, no proper name change filed. And Superpro, well, it was undeniably an entirely new corporation with its own SEC certificate issued on February 8th, 2000.
Okay, so the CA agrees Superpro is new. But how did that lead to reversing the decision against Total? Didn't that confirm Total's point?
But this is where the legal doctrine of estoppel came into play, according to the CA.
Estoppel. Remind us what that means, basically.
Essentially, it means you can be prevented or stopped from asserting something if your previous actions or statements contradict it, especially if someone else relied on those actions.
And how did the CA apply it here?
The CA held that Total was estopped from pre-terminating the TyrePlus agreement. Their reasoning was that Total knew Superpro was a new corporation. They argued Total was told about it. They were even given a copy of Superpro's certificate of incorporation back on February 10th.
So the CA's logic was, Total knew it was dealing with a new, distinct entity, Superpro, yet it still entered into a second distribution contract with Superpro, while the TyrePlus contract was technically still active.
Exactly. The CA felt Total couldn't then turn around and claim they were surprised, or that TyrePlus breached the non-assignment clause by dealing with Superpro, because Total itself had formally engaged with Superpro.
That's a very different take than the RTC. What did the CA award then?
They granted Lim and TyrePlus significant damages, P$400,000 in actual damages, covering promotional expenses, vehicle costs, business injury, P$150,000 moral damages, P$50,000 exemplary damages, and P$178,000 in attorney's fees.
Wow. So TyrePlus gets damages. What about the money TyrePlus owed Total?
The CA did still order Lim and TyrePlus to pay Total the original P$472,962.30 unpaid obligation. But overall, it was a massive turnaround from the RTC ruling.
And Total's attempt to get the CA to reconsider.
Denied. The CA stood by its decision in September 2012.
Okay, so we have two completely contradictory decisions from the lower courts. The RTC says Total was deceived and justified. The CA says Total knew what was happening and was stopped. This had to go to the Supreme Court, right?
Absolutely. Total elevated the case. And the core issue for the Supreme Court was pretty clear. Did the Court of Appeals mess up when it ruled? Total had no basis to pre-terminate its agreement with TyrePlus.
And given the conflicting findings below, the Supreme Court had to really dig into the facts themselves, didn't they?
They did. Usually the Supreme Court relies on the factual findings of the CA. But when the RTC and CA have contradictory findings, like here, the SC is allowed, even compelled, to re-examine the evidence themselves.
So what did the Supreme Court find when they re-examined everything, specifically on that estoppel point?
They fundamentally disagreed with the Court of Appeals. The Supreme Court ruled that estoppel does not apply to Total in this situation.
Why not? What was the SC's reasoning?
The key reason was Lim's conduct. The SC found that Lim, acting as president for both TyrePlus and Superpro, deliberately made false representations to Total. He actively misled them into thinking TyrePlus had simply changed its name.
And the Supreme Court pointed to specific evidence of this misrepresentation.
Yes, they laid it out clearly. There was Lim's January 31st letter on Superpro letterhead claiming it was the new trade name, his verbal statements in the February meetings, the fact that Total's products meant for TyrePlus ended up being handled by Superpro.
Wow.
So that PS Bank letter of undertaking, remember? The one referring to Superpro and its predecessor TyrePlus, and Lim's own February 26th letter where he guaranteed TyrePlus's debts, but also claimed Superpro was created after dissolving TyrePlus. The SC saw this pattern of contradictory statements as evidence of deception.
So the SC concluded Total initially acted in good faith, believing Lim's story.
Correct. They found Total was initially taken in by Lim's representations, which is why they signed that second agreement with Superpro, thinking it was just a formality for the supposed name change.
And what did the SC see as Lim's ultimate goal in all this?
The court concluded Lim's end goal was to be able to secure from Total 2 agreements for each of his two companies in circumvention of Total's one distributor, one area business policy. Basically, he wanted two distributorships where Total only intended one.
That makes sense. And the SC had something to say about the purpose of estoppel itself.
They did. They emphasized that estoppel is an equitable principle. It's meant to protect an innocent party from someone else's double talking or double acting. It's not meant to be used as a shield by the person who did the misleading in the first place. Lim couldn't hide behind estoppel when he was the source of the confusion.
So if estoppel didn't apply, what about the breach of contract, the non-transferability clause?
The Supreme Court was firm on this. They ruled that when TyrePlus effectively assigned its distribution obligations and the handling of Total's products over to Superpro, it was a direct violation of the non-transferability clause Article 9 in their original agreement with Total.
And that violation justified.
That violation, the SC stated, unequivocally warranted the pre-termination of the agreement by Total. Full stop.
Okay, so Total was justified in terminating the contract. Now, what about Edgardo Lim himself, the man behind both companies? Was he going to be held personally responsible for Tyreplus' debts?
This is a huge part of the decision, the concept of piercing the corporate veil.
Right. Usually, a corporation is separate from its officers, protecting them personally.
That's the general rule. A corporation has its own legal personality. To hold an officer personally liable for the corporation's debts, you typically have to prove something more.
What exactly needs to be proven?
It has to be alleged and proven that the officer did things like approve patently unlawful acts, or they were guilty of gross negligence, or, critically here, acted in bad faith. And that bad faith or wrongdoing needs to be shown with clear and convincing evidence.
Did the Supreme Court find that level of proof against Lim?
They absolutely did. They described Lim as the frontrunner and the controlling mind behind both Tyreplus and Superpro. They pointed to his actions, knowingly misleading Total through letters and meetings, creating the confusion between a name change and a new entity.
What else factored into finding bad faith?
The fact that he later changed his story, admitting Superpro was new after initially claiming it wasn't, then, crucially, ordering the stop payment on those checks for Tyreplus's debts without a valid reason, and finally initiating the lawsuit against Total on behalf of Tyreplus after all that.
So the SC saw a pattern of deliberate deception and manipulation.
Yes. Their conclusion was that Lim dealt in bad faith and essentially misused the corporate structure of Tyreplus to orchestrate this breach of contract. Therefore, the corporate veil could be pierced. Meaning
Edgardo Lim was to be held jointly and severally liable with Tyreplus for Tyreplus's allegations to Total. He couldn't hide behind the company structure. He was personally on the hook.
That's a significant finding. So, with Lim personally liable alongside Tyreplus, what were the final monetary awards the Supreme Court settled on?
Okay, let's break down the money. First, the unpaid obligation for the petroleum products Total delivered. P 472,962.30. That amount stood.
And the damages for the advertising materials?
Also retained. That was P 401,308.64 in actual damages, which the SE noted was properly evidenced by a bill of lading.
What about the liquidated damages the RTC initially awarded?
That was deleted. The Supreme Court pointed out that the original distributorship agreement didn't actually contain a specific clause for liquidated damages, so the P 25,000 award was removed.
Interesting. Any other damages awarded? Yes. The SC awarded P50,000.00 in exemplary damages. This wasn't just about compensation, it was punitive. The court stated it was because Tyreplus failed to honor its contract and needed to serve as an example for the public good, basically, a penalty for the bad faith.
And attorney's fees.
Those were retained as well, P94,585.26. The SC agreed Total was forced to litigate to protect its rights, and this amount was based on a clause in the contract allowing for 20% of the principal claim.
So a significant amount owed by Tyreplus and Lim personally. What about interest on these amounts? That can add up over time.
Right. The SC applied the standard rules based on the Nakarvi Gallery Frames case. For the unpaid obligation of P 472,962.30, it would earn legal interest of 12%. 12% per annum, starting from March 9, 2000, the total first demanded payment, up until June 30, 2013.
Why that specific date?
That's when the Banco Central in Pilipinas changed the official legal interest rate. So from July 1st, 2013 onwards, until the SC's decision became final, that obligation would earn 6% per annum.
Okay, and then interest on the total award after the decision.
Yes. Once the Supreme Court's decision became final, the entire amount due to Total, that's the unpaid obligation, plus the actual damages, exemplary damages, and attorney's fees all added up, would then start earning legal interest at 6%. 6% per annum until it's fully paid.
So the final ruling, sum it up for us.
The Supreme Court reversed and set aside the Court of Appeals decision. It didn't agree with the CA at all. Instead, it reinstated the original RTC decision, but with those modifications we just discussed regarding damages.
And that Avon line order.
Tyreplus Industrial Sales, Inc. and Edgardo Lim were ordered to jointly and severally pay Total Petroleum Philippines Corporation all those specified amounts, plus the applicable interest. A clear victory for Total in the end.
This case really provides some important takeaways, doesn't it? Key legal doctrines illuminated by this whole situation.
Absolutely. First, estoppel. We saw how it works preventing someone from contradicting their prior actions if someone else relied on them. But crucially, the SEC clarified it's not a shield for the deceiver. You can't cause the confusion and then claim estoppel.
Makes sense. What's next?
Piercing the corporate veil. This case is a strong reminder that the separation between a company and its officers isn't absolute. If you use the corporation to commit fraud, act in bad faith, or dodge obligations like the SC found Lim did, you can be held personally liable.
A warning for corporate officers everywhere.
Definitely. Then there's the straightforward but vital point about contractual breach and non-transferability clauses. Contracts mean something. Specific clauses, like prohibiting assignment without consent, are enforceable. Violating them has real consequences, including termination.
Don't ignore the fine print, basically.
Pretty much. And finally, the application of legal interest rates based on NACAR v. Gallery frames. It shows the clear, established framework for calculating interest on monetary judgments in the Philippines, ensuring fairness over the long period these cases can sometimes take.
So a really comprehensive look at corporate dealings gone wrong.
It really covers a lot of ground, from contract basics to complex legal doctrines and personal accountability.
It really does. And it leaves you thinking, doesn't it?
Yeah.
You know, where is that line between a savvy, maybe aggressive business move and actual bad faith? How much digging, how much due diligence is enough when you're dealing with partners?
It's a tough balance in the real world.
What stands out most to you listening to this deep dive into corporate identity, deception, and who ultimately pays the price?
We're genuinely curious about your perspective on this one.
Let us know your thoughts down in the comments. Hit that favorite button if you found this exploration valuable. And of course, if you want more deep dives like this, unpacking complex cases and issues to help you stay truly well-informed, make sure you subscribe to The Deep Dive.
Join us next time as we tackle another compelling topic.